Consider two groups of people accused of crimes, those who are guilty and those whom the public thinks are guilty. The two groups may be mostly overlapped, but not entirely. The second group is actually much larger, and the extra space could be called the witch trial space. Who is actually guilty is determined by first-hand witnesses, who are not internally influenced or externally pressured to lie, based on any agenda toward a preferred outcome. Whom the public thinks is guilty is influenced by police, by the ability of the state to hide information, and by civil law, which says the media are only allowed to say what police say. Elected officials get elected for convicting whomever the public thinks is guilty. Elected officials do this by using media, social pressure, and threats of prison to get the public narrative into the mouths of witnesses. This is a primitive tribal process where the people decide collectively who is guilty. With specialization and division of labor, this evolved into the more complex design of how the US justice system is supposed to work. People don't like independent knowledge institutions like courts and businesses. They like to vote to consciously control everything that affects them. So we lie to the judge and lie to the jury, with no risk of prosecution for perjury, to make sure we get the outcome the voters want. Lying nullifies the role of the judge and of the jury, and simplifies back to the primitive tribal process people prefer. The US Supreme Court said in Imbler v. Pachtman that judges will sign unjust lies to make sure the prosecutor is free to get any outcome the public wants. The Supreme Court suggested 14th Amendment Section 3 is unenforceable because courts are not capable of doing anything except rubber-stamping the will of the executive branch. They suggested if state courts could remove presidential candidates from ballots, executive officers in every state would remove whatever candidate they disliked. Not constrained by law, but needing only arbitrary whim. The US Supreme Court doubts courts and laws can exist, that don't simply reproduce the passing whim of the 51% majority. Perhaps as many as 100 million people believe Donald Trump committed no crime in New York. But a prosecutor can just walk into court and get Trump fined $354 million for no more reason than Trump is politically unpopular in the state. Soros prosecutor Andrew Warren recently boasted of using this arbitrary executive power in a virtuous way to free a man, Robert DuBoise, who was convicted using fake evidence and lying jailhouse confession witnesses, and spent 37 years in prison for a crime he had nothing to do with. Warren admitted the state can use lies to hold anyone unless you can prove your innocence. Warren admitted that rather than telling jurors the truth that state witnesses can lie without penalty, it depends on prosecutors to exonerate people and prove their innocence, because jurors are never brought up to speed on what prosecutors know.
I just left a Tampa City Council meeting where later today they will vote to compensate a man named Robert DuBoise. Robert spent 37 years locked up for a rape and murder that he didn't commit. I'm proud to have led the charge to exonerate Robert. DNA evidence proved his innocence and led us to the two men who actually committed the crime, men who we ended up indicting a couple years later. Robert's exoneration exemplifies prosecutorial success, freeing an innocent person, aggressively investigating and prosecuting the actual perpetrators, delivering justice to the victims and their families, and finding ways to improve our system. Now, I don't know how you put a price on having lost 37 years of freedom, but I trust our elected officials, our city council members, and our mayor to make that decision. After all, that's how democracy is supposed to work. What I do know for certain is that a prosecutor's search for truth and justice never ends. And today is the end of that 40-year search for justice. It's a huge victory, not just for Robert, but for the entire Tampa Bay community and everybody who believes that the time is always right to do what's right.
Tampa Police Chief Lee Burkow said it is in fact police who determine guilt or innocence. Burkow said, "What happened to DuBoise could not happen today, because police have been trained better to not frame the innocent. They still use jailhouse confession witnesses in Florida today, and CSIs like Alison Smolarek are still encouraged to straight lie on the stand without going to prison. So police can still frame people like Mandi Mae Jackson at will, to the extent witnesses are still allowed to lie, and this is still hidden from the jury. Burkhardt only claims police have been better trained to figure out who is really guilty, before blowing off the courts with lies. The real problem then and now is jurors are never told state witnesses are allowed to lie. And neither the witnesses nor the prosecutor ever face any penalty, but only a reward from the public and courts for lying. So if you are ever on a jury, just remember one thing. Every state witness is allowed to lie to you without any risk of being prosecuted, so long as the public thinks the defendant is guilty. In fact, sheriffs, judges, and prosecutors will lose elections if they don't use lies to nullify the court and jury, to give the people whatever they have been told on TV and Twitter is justice.